We have already formed a quorum. Let's call the meeting to order. Thank you for coming to the meeting. Minutes of the meeting held on the 22nd of April have been circulated to members. The Secretariat has not received any proposals for amendments. Shall we confirm the minutes? All right, thank you. Next, let's invite the administration team to join us. So let's invite the officials to join us. First of all, welcome to the government officials. I don't think I need to introduce them here. Let's get back to our business. Last time, we put some questions to a deputation, and we asked them about real estate trust, and the answer from the association is that it's less than 10%, and therefore the impact should not be significant, and therefore we will not be taking that up any further. Next, let's invite the administration to walk us through its paper. Paper number 1186/1203, right? Yes, Chairman. Last time we talked about contract law and trust law, and also some of the statutory requirements under them, and we have discussed with the DOJ, and we have noticed that for the two branches of the legal system, there is some difference, and actually in the UK situation, we have already got some case law with regard to the control of exemption clauses ordinance, and it said that the requirements would be different, and therefore initially when we said that we should have exemption clauses, that's because under the common law we do have this term fraud, and that's done by means of express provisions, and here we have actually strengthened the safeguards, and therefore willful misconduct and also gross negligence have also been included. We believe that that's to strengthen the safeguards. And also last time we also talked about certain clauses in contract law, and that might have an impact on that. So that's what this supplementary information paper is about. And we also refer to some additional or supplementary submissions from some deputations, and we looked into them one by one, and now we have come up with this further response. Is about the abolition of the rule against perpetuities, or RAP. And just now, well, Chairman, you referred to a response, and that's also very relevant because in practice, under the existing trust, where residential properties are involved, it's not just that it's less than 10%. Actually, that would also cover commercial residential properties, and therefore for residential properties the percentage should be even lower. And actually under our legislative proposal concerning the RAP, we are not going to allow existing trusts to apply this. In other words, for existing trusts, at the time of establishing the trust, whether or not it's 80 years or whatever, so that would still be valid or enforced, and therefore the sector's response is that well, for the existing trust, they would not be affected by the existing legislative proposals, resulting in that they could be changed into perpetual trust. But then after or upon the enactment of the new law, for trusts that come into effect after then we will apply this, and there will be perpetual trust, and that would also give them greater flexibility, because generally speaking, actually for trusts themselves, they are not perpetual in nature, but then we are actually doing this so that it could become more attractive, so that there would be an incentive for other people to come over to Hong Kong to establish trust. But then, of course, according to the trade, no less than 7 overseas jurisdictions have this perpetual trust. But then for major common law jurisdictions, there isn't any, and therefore after we have introduced this, and if we are able to enact that, then amongst our peers, for example, Singapore and UK, for these common financial centers, we will have an edge over them. Another point is anti-Bartlett and versus Barclays clause. Well, actually, we already explained our consideration at the last meeting, and we do not propose to bother you with further details. We will continue to discuss with the sector or the trade. With regard to exemption clauses on gross negligence, we have looked into that in conjunction with the DOJ. We believe that in other common law jurisdictions there isn't such a definition, and if we do not adopt the current approach, if we try to define what's meant by gross negligence in express provision, then that might give rise to a more serious problem. That is, how do we interpret the current situation? And if we were to come up with a definition, we believe that is a bit hasty and is a bit too early. We believe that we will need to look at the development of the case law, so that when the time becomes more mature, then we could also turn it into express law or codified law. And also with regard to the checklist, is not going to be controversial, and we are going to maintain the Schedule 2. That's to help those people who try to establish trust amongst friends. That's the authorized list of investment. And there are also other views that are technical in nature. In the annex to the paper, we have also addressed those one by one. But then as they are really very technical in nature, and many of them are actually not controversial, but we believe that when we come to clause by clause examination, we'll have a chance to look at them. Yes, thank you, Deputy Secretary. I think the response is already rather detailed, and we've already got that in black and white. So next, I'll ask the legal advisor to see if she has anything to add. Yes? Well, legal advisor, after the administration has spoken, we'd like to know if you have anything to add from the legal point of view. Well, last time, some members asked about this paper concerning the distinction between trust and contract, and well, the administration has now come up with a paper, and I have nothing further to add, and basically I agree with the administration's interpretation or explanation. All right. Now that the legal advisor has confirmed the administration's view, I think it's fine with members. Okay. Are there any further comments from members on these? If not, yes, Martin. Yes, Chairman. I'd also like to comment on the issue about RAP rule against perpetuities. Well, the administration is going to scrap that, and the only reason is
to land. The proposal to abolish RAP as applied in Hong Kong was intended to enhance Hong Kong's attractiveness as a trust domicile. Now, 當然我
Well, yes, personally, I support the proposal to establish Hong Kong as an investment and asset management center. But as the Deputy Secretary said, there would be incentives and we would also have an edge over the other jurisdictions. But I'm not sure about this. That's why I'd like to ask several questions in order to test if that can really be founded. With regard to RAP and whether it should be scrapped, I'd like to ask if the administration has considered whether or not there might be some legal conflicts. There might be a conflict of law. For example, if there is a trust being established in Hong Kong, it's a perpetual trust. But then, as it's an international trust, and of course, assets can be all over the world, and therefore, to put it in simple terms, let's say part of the assets are now in UK, and then in the UK, it might be involved in litigation, and the court will look at the law that would be applicable, whether or not it should be the law in Wales or Scotland or Hong Kong, and let's say if there isn't this governing law in Hong Kong applying to them, then there is a possibility or a chance that the asset might involve land and so on. Then they might opt to go to the UK. And in other circumstances, if there is no law applicable, then they will also refer to the UK law as a basis. And if the applicable law specifies that it should be Hong Kong law, then it doesn't necessarily mean that the court would go for or opt for Hong Kong laws in considering the case. It would consider whether or not it would be using or applying Hong Kong's laws or the UK laws or the Wales law or Scottish law. It depends on the merits of the case, and therefore, after you have scrapped it, all right, if some of the assets are overseas assets, then they may not necessarily follow the Hong Kong law.
So, I don't know what advantage there is here, because if it's an international trust, I can have one in New York, Zurich, Congo, London. I can set up a trust domicile in those places. However, I only need to provide expressly that only the Hong Kong law would be applicable, and then there is no need for me to actually set up the trust in Hong Kong. Do you get what I mean? They can choose not to come to Hong Kong. They can set up a trust in New York and state that the Hong Kong laws should apply, and the court will then decide, should the litigation involves assets in Hong Kong, whether the laws of Hong Kong or the laws applicable to New York should apply. And so I don't see the effect. Let's say if we abolish the RAP, then very probably it will only tie down the assets in Hong Kong but not assets overseas. So whether it's as effective as claimed, I'd like the administration to consider the situation. Any response, Deputy Secretary? Thank you, Chairman. To respond to Mr. Liao's question On the 19th of March, after the discussion, we had a paper issued in April, and we also admitted that for the UK trusts, they can be perpetual trusts, and should the asset involve land, then the UK law will apply, and even if the trust has domicile in Hong Kong, if the asset involving land is in UK, then the UK law shall apply, and we're clear about that. And I hope members would also note that where real estates are involved, I mean the present situation is that real estate only accounts for a very small percentage of assets put in trust. On the other hand, if the rule against perpetuities is abolished, then the sector will be able to promote their service. They have the professional base in Hong Kong. They have the professional knowledge. Of course, you can say that we don't have this system, whereas in Tokyo they already have this system. There is nothing we can do. But once the rule is abolished, then the sector will be able to compete with other competitors in, say, Tokyo, etc., with this trump card called perpetuity. We believe that this will provide us with an edge and a selling point, and from the sector, it's understood that they're talking about offshore places for trust business. Our target is not to compete with these jurisdictions, but rather an element would be given for us to compete with other common law jurisdictions, because we have this element whereas they don't. So we may not be able to quantify the advantages, but when we talk about the overall picture, this is an innovative and attractive point that would put Hong Kong as the first choice of these potential customers. Mr. Liao, a follow-up question. Do you agree that, say, if overseas assets are involved, as mentioned by the UK example that I quoted just now, if the domicile is in Hong Kong, then in considering which set of laws should apply, the English courts will consider the domicile as one of the factors for consideration. So, in fact, the incentive is not that great. It's only for the court to consider. If we talk about international trusts, because there are assets all over the world, and you're just providing one more factor for the court to consider. So I am doubtful about the so-called advantages. Maybe I'll defer to my colleague, Mr. Yu, to supplement. As we understand, for a common law court to consider which set of law should apply to the trust case, it largely depends on the stipulation from the set law as to which set of laws should apply. Now, for us, if in the trust deed it expressly provide that the Hong Kong law should apply, then for another jurisdiction, when considering a trust case, they should there is a very major factor for them to consider applying Hong Kong's laws. But where real estate or immovable property is concerned, then mostly the court where the immovable property is will take charge of the case, and the law there will apply. But for other forms of assets, it has relatively higher liquidity, for example, cash, and if necessary, the trustee can also rearrange the assets. And I think that in this regard, this is helpful. Mr. Liao, I agree that when considering which set of laws should apply, the set laws wish is also one of the court's considerations, but this is just in principle. When it comes to actual cases, we see that this is not really binding. So, Mr. Yu, if you've read the case laws, yes, on the one hand, I confirm the principles. It's the principles endorsed by courts, but I am asking Mr. Yu whether he can confirm that on receiving such cases involving trusts with domicile in Hong Kong, apart from immovable property or real estate, is it the case that even courts in other jurisdictions would accept the application of the laws of Hong Kong? Is it feasible? As my understanding that I was talking about general principles. If we talk about which set of laws should apply to the trust, then the court concerned will usually respect the wish of set laws. But it also depends on what the litigation is about. It's about a transfer of property held on the trust or other litigation issues. The court may have different considerations. But judging from the common law system or the trust law in the common law system, the set law's wish will be respected. But as for movable properties, the trustees can move the assets, so this may not be dealt with by other jurisdictions. Next, Mr. James Toh. I'm sorry because sometimes meetings clash. I got this information. I see from the letter, from the Hong Kong Trustees Association, that there are over seven trustees jurisdictions that allows perpetual trust. So I'd like to know what jurisdictions they are talking about. Say, if we do not abolish the RAP, we'll be losing out to Singapore, as mentioned here. I'd like to know, for these jurisdictions which have abolished the RAP, I'd like to know whether it's a total abolition or what choices were made and why some chose not to abolish the rule. Say, some jurisdictions may recently have undergone reform and they might have relaxed the rule, and I'd like to know by how much the rule was relaxed. I'd like to know something about their considerations. And the Law Reform Commission, or it might be a result of financial reform, and I'd like to know more about that, Chairman. It is best if the administration has this information. Otherwise, the Hong Kong Trustees Association, or the Society of Trusts, I mean, it's an international association, so maybe we can trouble them to give us information. But perhaps let me ask the administration first. Yes, before the administration responds, I'd like to remind members that in the first we have already invited the administration to brief us on the papers, and we have also invited the legal advisor to respond. So please don't repeat the points. I understand members have to travel between conference rooms. I will ask the administration to respond first. Thank you. Chairman, we don't have this information. The industry has about the 7 jurisdictions. They're all offshore, and they are fully perpetual trusts. And like we said, the sector would like to be able to compete with the offshore counterparts, but this is not our target. I suppose they have this information, and they've also told us that they would be happy to provide more information to the committee. So I can make this request to them after the meeting. Yes, please do ask for more information. Now, about perpetual trusts, I think we need to be careful because these are offshore businesses. Some might be a small island, and the island could disappear completely if there are geological changes. Let's imagine the tsunami in Japan, and a prefecture. Part of the prefecture in the northeast of Japan was gone after that. So if the island then disappears, then, well, that's a consideration. Of course, we can have a second jurisdiction. I've heard about it. It's very complicated, but I don't know that myself. That is, even if the jurisdiction no longer exists, it can be deemed to have a second jurisdiction, as long as the assets are not actually held within that jurisdiction. It's very complicated, but I understand the logic, and in particular for financial centers or rather major economic entity, I'd like to know what these jurisdictions are. Please ask them for information. All right, please ask the administration to follow up on this and gather some information, as supplementary information for members.
Chairman, concerning Singapore, well, you can also ask them, i.e. their industry, and I wonder if there is a trend like that and what the implications might be. Because, if it's business that has been attracted elsewhere, but then ultimately we also have to think about the impact. To what extent will that affect our status? Because the impact might not be that there might be some physical transfer of assets out of Hong Kong, but then it might be just documentation and also lawyers involved in preparing the documents. How many more will be coming over to Hong Kong to settle? It might not necessarily mean that they will be settling in Hong Kong, but then in preparing the trust, they are just using your jurisdiction to set up the trust. And for the individuals, they do not have to come themselves in person. So I'd like to know the latest trend, because after changing certain measures, so what benefits will that bring to us? All right, they might just rely on Hong Kong laws and the jurisdiction, and if they have to take the matter to the court, then they'll be forced to have their litigation in Hong Kong, or else, for whatever reason, they might choose to go elsewhere, and then they can also rely on Hong Kong laws in fighting their case. Well, unless they have physical assets in Hong Kong, then some of these might involve mandatory execution, and as a result, they might be forced to come to Hong Kong. And therefore, concerning relative competitiveness, recently we have also read an article written by Leung-sing. So I think the myth is that because, actually there was another gentleman writing an article some 20 years ago about relative competitiveness. But then if you're talking about competition amongst different jurisdictions, in fact, that would be even more abstract and vague. So, and for the actual impact on Hong Kong, it might not have been as serious as we might have thought, and therefore we have to be very careful in thinking or considering these. All right, any response from the administration, or else maybe in the supplementary information paper that you're going to provide, please also look at the concerns raised by Mr. James Toh concerning Singapore. So try to see if you can collect further information for us. Next, Ronnie Tong. Thank you, Chairman. Well, I was otherwise engaged. That's why I wasn't able to attend for a period of time. My apologies. In fact, on more than one occasion, I have to admit that with regard to land inheritance rule, I have this inherent resentment, even during my school days. Well, I've been working in trust law for several decades. Well, as far as I could recall, there were no more than a handful of such cases, and for those handful of cases, they were actually very major trust disputes. So there weren't any small cases at all. Well, I can understand members' concerns, but then when I read the letter from the gentleman, actually, if I remember it correctly, he's also a very senior and experienced lawyer. Well, sometimes there might be confusion. Well, whether it's a trust and wherever it's been set up, and if it involves Hong Kong's immovable property, then only Hong Kong laws will apply. That's an internationally widely recognized principle or rule, so it's inescapable. And therefore, the notion that you should refer to case laws elsewhere or principles, you can only look at how they deal with such cases within their jurisdiction. In fact, that's not going to help Hong Kong. So I don't think that would be very useful. On the contrary, I think the most important principle is that concerning this perpetuality, does it really exist in Hong Kong? I don't think that's the case, because other than St. John's Cathedral, there is nothing that is perpetual. We do not have fee simple. Since the colonial days, we haven't got it. We haven't had it. And even during the colonial era, you would only be granted lease for several decades. Yes, under the basic law, you will only be granted renewal of lease for another 50 years. And elsewhere in China, actually, there is no such thing called perpetual land right. If my understanding of Chinese laws is correct, of course, well, yes, I've been involved in many disputes or litigation involving Chinese laws. Actually, for the superstructure and also property, in fact, under Chinese laws, the communist principle is that you do not hold the land, you do not own the land per se. So, in Hong Kong, is it possible to keep or hold land in certain people's hands? In practice, that would not be the case, because the most that you'll be able to get is land ownership up to 2047, and then upon expiry of that, at most the government might be renewing that for another 50 years for you. So is it really worth our time to discuss that, and also trying so hard to find information to confirm it? Well, whether or not it's for 100 years or 150 years, would that be effective or valid at all? Because in the end, under the basic law, it provides that our land system will only remain for 50 years unchanged. So I think we need not look into it any further. All right, that's your view. I wonder if the administration would like to respond to that. Yes, I fully share that view. Well, maybe Mr. Tong. Well, as you were otherwise engaged. That's why you were not involved in that discussion during the past few meetings, because we have already tried very hard to explain to members with regard to concerns in land, well, whether or not it's perpetual or is upon renewed lease and so on and so forth. Our explanation is that because some members raised this, because if we were to allow this to be perpetual, all right, in the UK there were concerns. That's why, as we explained, the reason why in the UK they still impose this validity of 100 years. But then in Hong Kong, why we do not need to consider this? Because we do not have similar circumstances. Because with regard to land, the fact that you're concerned that people might be holding your land forever, well, that would not happen in Hong Kong. That's why, from that perspective, we believe that in scrapping that rule, it has nothing to do with land, and it will not have any impact on land at all. Yes, some members still challenge it. But then, just now, as we said, we were talking about overseas such laws, and they might be owning land overseas, and they might wish to put that in trust established or set up in Hong Kong. Or, for example, if they have a piece of land in the UK, that might be affected, because in the UK there might be a restriction of 80 years or 100 years, as we explained. Well, for the land that's there, then of course that would be dealt with in accordance with the UK law. But then, as we said, over 90% of trust assets would not be land, and therefore there are many benefits in allowing for perpetual trust. In fact, Hong Kong's laws, or in other places' laws, they cannot go beyond Hong Kong's jurisdiction. In particular, when it comes to immovable property, well, it's an internationally recognized practice. All right, it's under private international law. Actually, it's made very clear that for immovable property, the local or domicile jurisdictions laws will prevail, and therefore, if in a particular place there is this perpetual principle, then it will apply. It's not for us to dictate or restrict how immovable property elsewhere should be dealt with. Yes, as we have already set that out in our paper dated 9th of April, that's why by perpetuality we're actually referring to Hong Kong land that will not be affected, and in overseas jurisdictions, in some cases there is an expiry date, others no. And therefore, we will have to apply the domestic legislation. And therefore, for movable property or assets, as they are movable, and if the said law has this wish, then yes, he can always move the property to Hong Kong. And therefore, we are trying to explain that for the perpetuality with regard to land use in Hong Kong, the impact would not be negative. All right, that would also be very helpful, because we've discussed that for a very long time, and we've already built a consensus. Yes, Dennis Kwok. Sorry, I was late because I was held up in another meeting. I think my stance has been very well expressed by Ms. Ronnie Tong, and therefore I don't propose to repeat that. But can I refer to the exemption clause, or am I already too late? Because I think I've already told Mr. Actually, I've also read the Bar Association's submission, and I understand that well, they have this view. And I've also talked about the concept of gross negligence. I've actually come up with a version following Cap 485. That's the Mandatory Provident Fund Ordinance, Para 26, concerning trustees' exemption clauses and the restrictions therein. So I try to follow that Para 26 in the MPFAO, and I try to deal with the concerns of the HKBA and other deputations concerns on the exemption clauses. So I'll be giving you a copy later, and I'd like to submit that to the Bureau and the administration, hoping that they can take a look into these exemption clauses. Is there any room for improvement? I believe that there is room for improvement so that it can be made clearer. So that's my view. Thank you. Administration, you don't have to respond right away. And if there is no need for you to respond to that right now, then well, we can start the clause by clause, and then you can consider it when it comes to that particular clause. Well, before you join us, Mr. Kwok, I was explaining the main consideration whether or not is the right time for us to consider this in greater detail, or should we, or is it appropriate for us to include that in codified law as to what it means? I think the most important thing is all along with regard to this subject. Well, if we were to explain that further by defining what's meant by gross negligence, there hasn't been any in-depth discussion. But then if you have got a new version for us to consider, I would welcome that. I would welcome views from all sectors. I think we can all discuss that. Well, if there is room for further improvement or whether or not it's a good version, well, we can all consider it. Yes, I'll give that to the secretary. Okay. So we will all consider it, and then after the administration has looked at it, the administration can also come up with a response. Okay, so for raw matters of principle, I think we've already discussed them time and again. Yes, not many members are here, but I think we have to grasp the time, and we will have to start our clause by clause examination. So shall we invite the administration to take us through this, and we'll try our best to finish as many as possible. Yes, thank you, Chairman. Thank you, members. We've all got, well, let's check if we are looking at the same paper, and the number of the paper is CB bracket 1, 700/12 to 13 bracket 01. Yes, it's the markup copy. Yes, allow me to hand over to Mr. Yu, who will walk you through. Yes, thank you, Chairman. Let me supplement. Other than paper 700, actually, there was an earlier version. It's about the commencement date, and our draft bill will commence after the SFST has appointed the date by Gazette. Yes, it depends on the final version, and we will take into account all the relevant factors, and actually we can all agree on a date to be appointed as the commencement date. Yes. Now looking at paper number CB bracket 1 700 bracket 01, well, on the amendments to clause 2 interpretation, actually in the new law we have to include some new definitions, including the name of the legislation, body, corporate, statutory duty of care, and trust funds. As these are interpretation clauses, and when it comes to later clauses referring to these terms, and if there is any doubt about this, we can come back to this.
Next page, page 2. That's amending Section 3 of the Trustee Ordinance. Section 3 sets the application of the TO, and we are going to redraft this section because the new provisions will replace sections 2 and 3 of the subsections 2 and 3 of the original section. But in effect, the meaning is the same. This ordinance applies to trust wherever created, including, so far as this ordinance applies, executorships and administratorships whenever constitutions. Now, in the existing TO, it only states trust deeds or trust instruments, and this will be governed by statutes. You think, and this is not very clear. So now we stipulate that the powers conferred on trustees are in addition to the powers conferred by the instrument creating the trust or an enactment, just to clarify this point. Next, on page 2, we're also going to add this clause 3A, which is a new clause, and this is the proposed statutory duty of care for trustees. 3A1 states that what the statutory duty of care is about. If the trustee, where the statutory duty of care is applied, must exercise the care and skill that is reasonable in two circumstances, having regard to A, any special knowledge or experience that the trustee has or holds out as having, under 1B, if the trustee is acting in that capacity in the course of a business or profession, any special knowledge or experience that is reasonably expected of a person acting in the course of that kind of business or profession. So this is the standard of statutory duty of care under subclause 1. Subclause 2, the statutory duty of care will take effect in place of any common law rules applicable. Subclause 3, the statutory duty of care does not apply to a trustee if it appears from the instrument creating the trust or an enactment that the duty is not meant to apply. And as mentioned many times before, this statutory duty of care is confined to a default setting, and subclause 4 states that and it's a result of the views expressed, because the statutory duty of care is default in nature. There is no provision for the said law to stipulate whether this applies to individual trustees, and having considered the views, we think that for existing trusts they should be exempted from the statutory duty of care. So the mechanism proposed under subclause 4 is that if the trust was created by a person who is still alive, then and who is of full capacity, then the person can set up another deed to relieve the trustee of the statutory duty. The other circumstances is that if the said law is no longer alive, then if the beneficiary is a sua juris adult and is absolutely entitled to the property subject to the trust, then the statutory duty of care can also be relieved by execution of a deed. Our consideration is that if the beneficiary is absolutely entitled to the property subject to the trust and is a sua juris adult, he can apply to a court to wind up the trust and get hold of the property held in trust. Because of the vast powers, we propose that for this kind of beneficiaries, they should be allowed by executing a deed to relieve a trustee of his duties. Nothing in particular. Please move on. If members agree, well, because the statutory duty of care is the scope of application, and this will be in Schedule 3 of the bill, and I will invite members to look at Schedule 3, and that's in that's on page 58 of the paper I mentioned just now. And the application of the statutory of care is divided into several areas, and we have referred to the relevant requirements in the UK law. The first area is when the trustee is exercising the default powers to make investments vested in him to make investments, he will be subject to the statutory duty of care. And secondly, if he appoints a trustee or default powers of trustees, then he will be subject to statutory duty of care as well. And thirdly, power to insure, and also fourthly, if he takes out insurance on behalf of the beneficiaries, and fifthly, in relation to valuation of properties, of the assets, and also audit of assets held in trust, then under these circumstances the statutory duty of care should apply. And just to supplement, the statutory duty of care is default in nature, and the trust can stipulate the scope of application of the statutory of care. Legal advisor. Chairman, about Schedule 3, may I share my point of view with members? Now it's on page 58, bracket B. It states that the statutory duty of care applies to a trustee where the trustee exercises a power in accordance with the provisions. And if you look at the trustee ordinance, section 6 is about the discretionary power of trustees. So a point of information for members' consideration. Now, about the powers exercised in accordance with Section 6 in Schedule 3, then the statutory duty of care should apply. But when Section 6 is about discretionary power, then in terms of execution, I hope members would consider in enforcing Section 6, there might be undesirable situations. Earlier on, we have noted the legal advisor views. This is about the power to make investments, and we have noted the views of the legal advisor. This has to do with the discretion of the trustee, and we think that this might not be applicable to the statutory duty of care, but we need to further clarify this point. If possible, we may make amendments to delete Section 6. Yes, please supplement that in writing next time. Thank you, legal advisor. If there are no questions from members, may I move on to amendments to Section 4, and that's authorized investments. We propose to amend Section 4.1 to clarify the legal position. Second schedule now it specifies any investments that the trustee can make, and we put down a condition here. That is, the investment is subject to the compliance with any condition specified in relation to the investment in that schedule. So just to clarify this point. No questions. Please move on. Chairman, you're looking at Section 4. Can you explain to me why under 4.1b it must be on summary purpose, for that purpose made in chambers? Is there any reason for this requirement? administration. Chairman, well, the ordinance was enacted in 1993. That was the provision enacted at the time. I do not have any information. And so no special reason for authorized by the court on summary application for that purpose. We're not proposing to amend this bit. We're just proposing to amend 4.1a. But is this requirement outdated? Is there a practical need now? If there is a practical need, then it can be retained. Otherwise, it's a bit too clumsy. So if it's not drafted this way, may I ask a member what should be written? So the last bit on summary application for that purpose made in chambers, I'm asking whether this is still a need in practice. Yes, go back and check, please.
如果冇問題咧，就係去到對第7條嘅修訂。其實
Amendments to Section 7. Now, if a trustee makes investment, which is an authorized investment, and where the investment is no longer an authorized investment, and if it continues to be held on trust, whether the trustee should be responsible. And in fact, there are provisions to deal with the special circumstances. There are provisions stating that the trustee is not liable in such circumstances, but sometimes a threshold would be set in the provision concerned. For example, the trustee must be in good faith for him to be relieved of the liability. And we have introduced the statutory duty of care in this bill. So in those exemption clauses applicable to the trustee, we also need to state that the trustee must also comply with the statutory duty of care before he can discharge his liability. So Section 7 states that a trustee shall not be liable for breach of trust by reason only of his continuing to hold an investment which has ceased to be an investment authorized by the trust instrument, as long as the statutory duty of care has been discharged. Any definition on statutory duty of care? Yes, Chairman. We have included the definition for statutory duty of care in our amendment bill, and that's in Section 2. Well, in fact, on page 1, for this CB bracket 1700 paper, now statutory duty of care in relation to a trustee means the duty of care required to be exercised by the trustee under Section 3A is read with the third schedule. And we have actually explained the statutory duty of care, and that is to say that the trustee either holds the professional knowledge or holds out as having the professional knowledge, or if the trustee is acting in the course of business or profession, then he's deemed to have the professional knowledge, and this is the standard that is used in the UK.
Is there any provision saying that if somebody hires a professional, but then if the professional gives a wrong advice or makes a wrong decision, then his legal liability will not be affected? I don't know if it's under trustee ordinance or the company's ordinance that this principle will apply. All right, if this individual has hired a professional who gives him professional advice, But then if the professional advice turns out to be wrong, then he, as the trustee, will not be held legally liable. Yes, in fact, there are already new provisions in the amendment bill. That is, if the trustee engages an agent or a custodial, and that would also include investment advisors, and if he engages an agent to deal with certain business, but then he would also be shouldering certain responsibilities. For example, he will have to review the conduct of the agent. He will also have to give appropriate instructions, and we will be discussing that later. And also with regard to the agent's conduct and who's held liable for what, well, there are provisions dealing with this. And for example, in appointing an agent and so on, if he has already set out the duties very clearly, then of course he will not be held personally liable for that. Next, clause 8. In fact, section 8 will be crossing that out. And under 41I, we will that is newly added clause. We will deal with the custodian's business, and we believe that it's more appropriate to deal with that in that clause. That's why this section has been deleted. Please continue. Next, amendments to section 11. As I said on section 7, there are different provisions dealing with trustees under certain circumstances. They will not be held legally liable. Well, 11.3 also sets out an exemption, and we have also included the statutory duty of care. In other words, trustees will have to comply with the statutory duty of care, and then only after that they will not be held legally liable for certain things in that section. Yes, legal advisor. Chairman, there is a drafting point, because in the English version, precisely because the amendment will be deleting the words "and shall not be," and then in the same clause there is a word "shall." So will the administration consider also deleting that word for consistency? Lord Draftsman? Yes? Ms. Poon? Yes, we have noted the comment from the legal advisor internally. We have also discussed that, but then the way it is drafted, the trustee shall not be bound to obtain any report, as if the trustee has discharged the statutory duty of care. The trustee are not liable for any loss which may be incurred. Actually, the meaning here retains the meaning, that is, he shall not be bound, and he will not be held legally liable, and therefore the words here are necessary, and therefore there is no need in our view to revise it or amend it. Thank you. 11.4. Number 1, there is a drafting amendment, because the way it was originally drafted was a bit complicated. That's why we're trying to simplify it. That's why for the second part of the paragraph under 4, we tried to organize it in a better way. That is, we have also included 4A and 4B, but then for the original effect, that has not been changed. The only change is, as I just said, as it involves the trustee, and the trustees are not held legally liable for acts in good faith, because we've already introduced the statutory duty of care. That's why this is a corresponding change, and therefore for the acts in good faith, they have been changed to statutory duty of care. Next, similar to subsection 4, subsection 5 has been rewritten and is now been divided into 5 and 5A. So it's a drafting change to make it more clear. And another change that has been introduced is that for acts and things done in good faith, that has also been changed into statutory duty of care, and the principle is the same. All right. Next, change to section 12, subparagraph 2. Well, the main change is in the original version deals with the trustee who may apply capital money subject to a trust in payment of the calls on any share subject to the same trust. And concerning individual clauses with regard to the capital money that can be used, we apply the same principle. That is, the trustee may apply the trust funds of the trust, and there is already a new definition. And in fact, for trust funds, it refers to the capital and also the shares. And therefore, the trustee should look at the actual circumstances of payment in considering using the capital or the income of the trust funds in the trust to make the payment. And in fact, legally speaking, as to how the trustee should be using the trust funds to make payment, in fact, there are relevant legal principles that will apply. And therefore, we believe that in the codified law, there is no need for us to have an express provision on it. And therefore, we should leave it to the codified law and also to the established principles that will apply. Okay. Chairman, because right at the beginning, we said that for the interpretation clauses under Section 2, we'll deal with them as we go along. And for the new interpretations that we have introduced, we will try to explain them along the way. For example, just now we talk about trust funds, and actually here it means any income or capital funds of a trust. So we hope that members will also take a look at that too. Yes, Chairman, if there are no further questions, then we can now move on to Part 3 of the Trustees' Ordinance. First of all, is a drafting and also a change in format, because now we try to make it clearer. So there will be this division 1, because there are other divisions, and therefore we believe that it's better for us to have a separate division on this. Next, change to Section 16. First of all, there are certain drafting changes. Initially, we have the him or them, and these are just drafting changes. But then there is another substantive change, as we have referred to that earlier. That's the threshold for acting in good faith. That has also been changed into discharging the statutory duty of care. Okay, if there are no questions, then next is changed to Section 21, power to insure. Well, as we have pointed out before, well, under the current trustee ordinance with regard to the power to insure by a trustee, there are certain restrictions. For example, he can only insure against loss or damage by fire and typhoon, we believe that such restrictions are no longer in line with the needs of the day, and therefore, in light of the new law in the UK, we have now proposed some changes. Number one, the trustee may insure any property that is subject that's under subsection 1A. He can insure any property that is subject to the trust against loss or damage due to any event. And secondly, he can also pay the premium out of the trust funds, because earlier on there were also other provisions specifying that he will have to use the income to make the payment of premium. We believe that we should leave it to the trustee, who will look at the actual circumstances and the situation in deciding how the payment will be made, and therefore the trustee can use the trust funds to pay for it, either from the income or from the capital fund. Moving on, there are other changes. For example, with regard to the power of the trustee, because initially under section 2, the trustee can pass this on to the beneficiary. That is upon the request by the beneficiary. If the trustee can immediately transfer the property to the beneficiary, that's the definition under the earlier version, and that's what you understand to be bare trust. And we have now updated that. So if it's a bare trust, if it's held on a bare trust, and if the beneficiary makes a direction that the trustee should not be investing in certain areas or should not be insuring the property, then the general understanding is that the beneficiary has the power to own the trust, and therefore under subsection 3, if the sole beneficiary under the trust who is absolutely entitled to the property subject to the trust, and if there is no ban on him for not doing this, then he can give direction to the trustee as to what he should be doing. Yes? Sorry, speaker's not coming through. Well, is my understanding correct? That has been changed already, right? Well, in fact, the Bar Association recently gave us some views on Section 21. We are now in the process of preparing a paper to respond to that. Actually, the Bar Association's view is mainly that it can see that there are some academics who are looking at the concept of bare trust, and in certain circumstances it may not be entirely clear. For example, if the trustee has the lien, i.e., if the trust property, if the trustee has a claim on the property, then will it affect the absolute entitlement of the beneficiary? Well, we have considered the view of the Bar Association, but then we'd also like to point out that for bare trust and also for the beneficiary, whether or not he has absolute entitlement to the property, in fact, this is a general concept. It's not just confined to the issue of insurance.
There are provisions following that state the beneficiary is absolutely entitled to the property, and Chairman also looked at this issue as to whether the beneficiary is absolutely entitled to the property held on the trust. This is a relative concept, and the court does have discretion in considering this issue. So we don't agree with the Bar Association that whether clarification is required in the event of the trustee having a lien over the property. We're actually modeling this provision on the UK Act, and it has been in operation for over 10 years without any problem. So we don't see the need to clarify the point here. Is it necessary to make a response or communicate with the Bar Association if we have accepted their submission but we have not made any amendments to the bill? Well, basically, the Bar Association submits their view on our invitation, on the invitation of the committee, and they're just expressing their views as to whether it's necessary to make this amendment. And our response is also available online for their perusal. What if you do not amend this provision but put a note in the explanatory memorandum? Is it acceptable? Well, if we can have this, then it will be better. Just a brief response telling them why, so that people who have submitted their views would feel that the issue has been properly handled. So I don't know roughly how much we are talking about, but this will be considered a response. Mr. Tong, Mr. Pat Hong, please don't leave just yet, or we will be lacking a quorum. Can we replace you with another member? Well, Chairman, if no one is asking for a quorum count, then I think it's possible. I have also been chairman of a BC, and I was the only member left. All right, sorry. We still have one left. So I was saying that it'd be best if you could do that. So please check whether this is the practice of the administration. If you say that your response is online and you're going ahead, and at least you can say that you have noted their view, then you can do according to your practice. So let's pause here. I was still on the same point. I don't know if other bills committees follow the same practice, that is to respond to the written submissions. Clerk? No, the Secretariat will not deliberately make a response. We'll just let them know that their views are noted, but that we will not necessarily follow their proposed amendments. So if the Bar Association requests any further elaboration of our response, we will follow up on them. All right, let's go on. Thank you, Chairman. Section 22. It's an amendment similar to the one to 21. 21 is about the power to insure. Section 22 is about insurance against loss subject to, in the case of fire. We have not set down the scope of the insurance, and we're going to delete this reference to fire, so that it's just a general description. We will not specify any special incident. Nothing special then. Section 23. Deposit of documents for safe custody. Under the existing trustee ordinance, a trustee may deposit any documents held by them relating to the trust in the safe custody. And now we have a general provision on the appointment of trustees. So this section 23 is no longer necessary. And in clause 41H, there will be a new provision on the safe custody of documents. The section numbers will be rearranged, right? I mean, after, say, section 23 is deleted. I'll ask the drafting division to explain this. Chairman, our established practice is that, for example, if here section 23 is deleted, then in the loose leaf edition of the ordinance, the title or the heading of Section 23 will be retained, but then underneath it will say repealed, because this is to facilitate users of the ordinance. They might not know what Section 23 is about, but if we include all the previous repealed provisions, there might be confusion. So if reference is necessary, according to our practice, we will retain those section numbers. Chairman, if there are no more questions, I'll move on to the amendments to Section 24. The amendment involves several aspects. Some are drafting issues. For example, as referred to in subsection 1 instead of as aforesaid, and we're also going to make other drafting changes. As for substantial changes or substantive changes, the first point is about relieving trustees of the duty. There is reference to the threshold made in good faith, and the made in good faith is now being changed to statutory duty of care being discharged, subject to our new amendment. And in conducting the audit, there is a question on how the fee of an auditor should be paid. As discussed, it should be left to the decision of the trustee, subject to actual circumstances. The existing TO states that the capital should be borne by the capital and those attributable to income by income, etc. But we don't think that it should be that detailed, so we will just put down a general requirement here. Section 25. It will be deleted because the power to employ agents will be replaced by a new clause, and power will be conferred to trustees to employ agents. So Section 25 will be deleted. If there are no questions, then moving on to amendments to Section 27. We explained in our previous papers that this is in relation to a trustee delegating his responsibilities to a power of attorney. So we are going to amend 1A to make clarifications. Now, under the existing TO, there is a requirement for a period not exceeding 12 months. So, under 1A, we're going to emphasize that it will continue for a period of 12 months. And under 1A, we also stipulate when this period of 12 months should commence, and that is if the instrument doesn't provide the commencement date, then it will be on the date when the instrument it's been created, or on the date when the instrument is executed by the donor of the power. Now, for 2A, originally, the power of attorney, say if there are two trustees, trustee A should not delegate the power to trustee B, because this will result in only one trustee, and this is against the wish of the said law to have two trustees in place so that there are checks and balances. So we're going to retain this requirement. And there is also another circumstances under which two trustees might be delegating power to one donee, so that in the end only one donee acts as the trustee. It's also against the settlor's wish. So we're going to impose a requirement here, and that is the exercise of the power of delegation must not result in the trust having only one donee under a power of attorney or one trustee administrating the trust. And this is just a redrafting of the previous requirement. And Section 9 is a transitional provision. This section, as enforced immediately before the commencement date, so on and so forth, as if this section had not been amended. That is to say, if the power of attorney is created before the commencement date, it will not be affected by this section. Next, Section 28. Now, a drafting point, we are going to insert Division 2. Section 32, about implied indemnity of trustees. So following the UK Act, we think that there should no longer be this requirement. This provision talks about the trustee being liable only for his own acts, and the negligence of other or defaults of other trustees will not result in any liability on his part. And we have referred to the UK Act. The trustees themselves have a statutory duty of care, so that even if it's not his own act of negligence, he still has a statutory duty of care. This is inconsistent with the statutory duty of care. And on the other hand, we also have a new clause that deals with the power of attorney and the custodian, safe custodian, and the liabilities for these personnel will be dealt with in the following provision. So we propose to delete Section 32. Next, before Section 33, we will insert Division 3. If there are no questions, then I'll move on to the newly added 40 capital A. This is one of our major proposals, and that is on beneficiaries' directions. The trustees can be replaced. This is again copied or modeled on the UK provisions. That is, when certain criteria are met, the beneficiary is not required to go through the court procedure. And this provision sets out the requirements. First of all, no person is nominated for the purpose of appointing new trustees by the instrument creating the trust or an enactment. This is to respect the settlor's wish. If the settlor's settlor has already stipulated in the trust instrument on who should make the appointment of new trustees, then his wish should be appointed, and the arrangement should be so in accordance with his wish. So the first requirement is that there should not be any requirement in the trust instrument on who should make this nomination.
Next, the beneficiary will have to have absolute entitlement to the property. The reason why we have to have this requirement, that's because if the if the beneficiary has absolute entitlement to the property, then theoretically he can just abolish the trust by going to the court. And in fact, as the trustee has already got a very strong power over the property, and if the beneficiary does not want to scrap the trust, and if he just wants to change the trustee, then he doesn't have to go to the court. All he needs to do is to change the trustee. He should have that right. With regard to the change of trustee, there are certain requirements, and what the sole beneficiary needs to do is that he will have to give a written direction to a trustee directing the trustee to retire from the trust, and next the trustee will also have to comply with the following conditions, and then he will have to resign or retire. Well, under 3A, there are already reasonable arrangements in place to protect the rights of the trustee in connection with the trust. That is, if the trustee is asked to go, then we believe that there should be provisions to protect his rights. For example, if there are certain monies that should be paid to him, then as a result of the change, there should be reasonable arrangements to safeguard his rights and interests before he needs to follow the direction in retiring. And after a trustee has been asked to retire, then at least there should be two persons to manage the trust within the trust corporation, or there should also be a trust corporation to manage the trust. That is, if a trustee is retired, then at least there will be sufficient checks and balances in place. And C also says that if a trustee has to be retired, then another person to be appointed would also have to agree, because if there are more than one trustees, then if one of the trustees has to retire, then that might have an impact on the other trustees, because the power or the responsibilities might increase, and therefore under the circumstances the other trustees will have to agree to this arrangement before the beneficiaries or the settlor's direction would become effective. So we have to take care of the interests of all the parties concerned before we can execute this direction. And next is about the actual arrangements. And subsection 4 is about the retirement of the trustee, and in the replacement of the trustee, how the assets should be dealt with, because it also deals with the number of trustees in a general trust. And here it says that for this particular trustee, if a trustee is retired and in appointing a new trustee, the relevant provisions would also kick in. In terms of the actual operation, for those trustees remaining, what if they do not agree to the retirement of a trustee, and if they do not sign on the relevant instrument? Then under the old law, are there any rigid requirements for certain things to be done? Chairman, this is a brand new mechanism. It allows the beneficiary to give direction for a trustee to be retired, because usually the beneficiary will have to apply to the court before he can replace or he can order a trustee to retire. So this is a court-free procedure. It's a more convenient way to do it, and therefore we have to ensure that the interests of all the parties will be taken care of. As for other trustees, for different reasons, if they do not agree with this arrangement, then the beneficiary will not be able to invoke this new mechanism to retire a trustee. And if he wants to retire a trustee, then he can only rely on the old mechanism of applying to the court. So this is a new way out for the beneficiary. So we are referring to the more straightforward cases. (40B) the beneficiary can also substitute certain trustees, and we're dealing with a special situation whereby the trustee is already incapacitated. So he's no longer able to discharge his duty as the trustee. And if that should arise, and there is also another restriction, that is no person is entitled, willing, or able to appoint. And if the trust instrument has already provided that if a trustee becomes mentally incapacitated, how should this post be replaced? Well, if the instrument has already got guidelines, then we will have to respect the settlor's mechanism as set out in the trust instrument. If there is no such a provision, then if the beneficiary is already an adult, and if he has absolute entitlement to the property, then he can replace the trustee who is mentally incapacitated, and what he needs to do is to give a written direction to the trustee or his guardian that he will no longer be the trustee, and by mentally incapacitated, actually, there are already provisions under Cap 136 Mental Health Ordinance, and under that ordinance there is already a specified committee or guardian, and therefore the beneficiary will have to issue direction to those two persons, and then the trustee will have to discharge his duty as a trustee, and that's in line with the provisions in the UK. Move on, please. 40C, provisions supplementary to sections 40A and 40B. Well, in a trust, there might be more than one beneficiary. Just now we talk about beneficiaries who have the power to give direction, and then 40C also refers to the different circumstances and how they should be dealt with. If there are more than one beneficiary, then all the beneficiaries will have to give a single direction, and in making that direction, in fact, this is to ensure that the beneficiaries in making the direction is clear, so that with regard to the replacement of trustee, if the direction is clear, then the trustee will be able to follow the direction in retiring, and in appointing the new trustee, there would also be clear directions. In subsection 3 says that under this provision, if a trustee is appointed, then the powers that he can enjoy would be the same as that being appointed under the original section. 40D also supplements section 40A and 40B. Is about the scope of application, because it provides very clearly that if the trust instrument or other express law has a contrary intention, then 40A and 40B do not apply. In other words, if a trust instrument says that the beneficiary does not have the power to replace the trustee, then this the settlor's wish will be respected, and therefore 40A and 40B, the mechanism under those two provisions, will not apply. And if the beneficiary thinks there is a need to replace the trustee, then he will have to go to the court. As this is a new provision, we would also like to deal with some old trusts or established trusts. Well, for some existing trust, and if the settlor has done it by way of a deed saying that 40A and 40B do not apply, then these two provisions will still not apply. Initially, when creating the trust, they might not be aware of 40A and 40B, and now they've noticed that they have this power under the new 40A and 40B, and if the settlor does not think that this applies, then he can also create a deed and say that 40A and 40B would not apply to the trust that has been created already. And if there is a deed to deal with this, then there are some technical arrangements in place. For example, he can also make a change, but then it doesn't mean that he can change more. He can change it more often. So he cannot go back and make a change, right? Well, this will apply to some trusts that have been created already. And therefore, we believe that there is a need for us to offer an avenue for the settlor so that they can also decide not to apply it. Because 40A and 40B are also subject to a number of conditions. For example, the beneficiary will have to have absolute entitlement to the property, because if that should happen, then the beneficiary can always abolish the trust and obtain the property. As this is a very unique circumstance, and there are so many restrictions, that's why we believe that it can be in place, or it should be allowed. But then he can also execute a deed to effect that 40A and 40B do not apply. Next, change to 41. In fact, it's a drafting change. The statutory power under 40 and 40A, because with 40A, there is a new avenue and a new power to deal with the replacement or change of the trustee, and therefore we believe that it should be clarified, it should be spelled out, instead of just putting the statutory power here. If members have no further questions, then we will move on to Part 4A, which is a new part, appointment of agents, nominees, and custodians. As we have explained in earlier papers, well, under the existing trustee ordinance, with regard to the appointment of agents, there are certain restrictions, and in fact, because of the change in trust, we have also taken reference from the UK experience. We have now incorporated that with regard to the appointment of agents, nominees, and custodians, there are certain general duties. Under 41A, it deals with the application of Part 4A, and it specifies that this will apply to trusts having one sole trustee or trusts that have more than one trustee. It's very clear. And secondly, it also says that if there are more than one trustee, then the power to appoint agents, then all the trustees will have to discharge the duties together. It's a joint decision, so they will have to make the decision together. As for the vesting power by individual trustee, well, that would be dealt with under Section 27. So for the general appointment powers, well, that would allow all the trustees to act jointly.
咁首先第二分部咧就係處理
Division 2, Agents. 41B empowers trustees to delegate their powers or authorize a person to exercise the power conferred in order to have checks and balances to prevent trustees from delegating the most important functions and thereby undermining the interests of, or the protection for the interests of the beneficiaries, we add the checks and balances here. Subsection 2 states that for a trust that is not a charitable trust, then the trustees' delegable functions are any functions of the trustees other than, and then A, B, C, D. And the functions in A, B, C, D are, for example, in A, a function relating to how the assets are to be distributed. And this is one of the fundamental functions of a trustee, so this cannot be delegated via 41B. Then, whether payment should be made out of income or capital of the trust, this is again one of the important decisions of trustees, and this should be done by the trustee himself. And next, the power to appoint person to be a trustee of the trust, that is to further delegate the or the power to further delegate the functions. This is an important function, and so this is not allowed. And subsection 3 is about charitable trust, because charitable trusts are different in nature, that they will be subject to more restrictions. Now 3ABC sets out the functions. The trustees of a charitable trust can only appoint agents in relation to the functions set out in ABC. For example, 3A, a function relating to carrying out a decision that the trustees have taken. That is, the trustees have already made the decision, and it is only related to appointing someone to carry out a decision. Next, a function relating to the investment of assets subject to the trust and raising of funds. We think that these are the functions that the trustee of a charitable trust can delegate to an agent. Well, there was a suggestion that a person should be changed to any person. I'll defer to my colleague in the drafting division. 41B1. Thank you, Chairman, and thank you for the Bar Association for their views. In fact, we have referred to the relevant provisions in the UK law. We find that where appointment of agents are mentioned in the UK Act, there are references to a person and any person. So the UK Act is not consistent in itself, and we think that in 41B1, a person, which is a term that we've chosen, can reflect the true meaning of the provision. In particular, in the Chinese version, it means any person. So the meaning is clear. Next. Thank you, Chairman. 41C stipulates who may act as agents. Just one point to clarify. Subsection 1 stipulates that where there are more than one trustee in a trust, then one of the trustees can be appointed as agents. Subsection 2, the trustees may not authorize two or more persons to exercise the same function. So where the trustees wish to delegate a function to someone, then the trustees may not authorize two or more persons to exercise the same functions unless they exercise the function jointly. Subsection 3, if a person has been appointed to act as the trustee's nominee or custodian, the person can still be appointed as their agent to exercise a function. That is in subsection 3, that the person can still be appointed as an agent even though the person has been appointed as a nominee or custodian. Well, I think we should pause here. Because no member is present. Anyway, so up to 41.3. We'll pause here for today, and the next meeting will be held on the 13th of June, is it? And we will inform members. We will continue with the class-by-class scrutiny on the 13th, so thank you, everyone.